is a Deputy Data Commissioner, Misozi Banda. From our end, we recognize that as much as you could be startups, the business environment that you are going to operate in involves all sorts of all the levels as far as business is concerned. You'll be dealing with, you'll be doing systems for big entities, for small entities, and the like. And this environment has got rules. As much as you could be a startup, you are coming into an environment which has got rules and regulations. And hence, it's important that you acclimatize yourself with this new environment that you're coming into. Among the rules that or things that you may need to be compliant with, which has recently come in, is a Data Protection Act. You realize that data has become, today is being said to be the new gold, because if you look at the world's biggest companies today, the commodity that they sell basically is really nothing else but data. If you look at the meta of this world, it's all about data. And this is why data now has become a commodity which should be looked at from a different manner, not the way it was looked at many years ago. Today, it has to be safeguarded, because if it's not safeguarded, there are implications. We know of ransomwares and all sorts of things that may happen. And all that is because it's how we maybe even manage our data. And that is why now it has become important that certain rules have been built to ensure that data, regardless of whatever level it could be at, it needs to be extremely secure. So we'll run you through the Data Protection Act, give you just a reasonable understanding so that you know that it impacts you as well, despite that you could be a startup in this environment. So I'll call upon Misozi to just run you through the act, then I'll come in towards the end. So let me just share the presentation. You may just confirm if Lukonga, if you're able to see the presentation.
Yes, we can see it.
Sorry, the slides are not moving. Just a moment.
Good afternoon, everyone. My name is Misozi Banda, Deputy Data Protection Commissioner. I'll run you through the legal provisions of our Act. So basically, the Data Protection Act provides for the use and protection of personal data. It regulates the collection, use, transmission, or otherwise processing of personal data, establishes the Office of the Data Protection Commissioner, and provides for its functions, registration of data controllers, and licensing of data auditors. It provides for the duties of data controllers and data processors. Our Act also provides for the rights of data subjects. The Commission's mandate. The mandate of the Commission is to ensure that there's effective use and protection of personal data through regulating the collection, use, transmission, storage, and processing of personal data. The Commission also has a mandate of ensuring that the data subjects' rights are safeguarded and that there's compliance and transparency in the use of the Act. The promises that the Commission has for the clients is that it ensures that the law is fairly and transparently effected. It ensures that the cost of doing business is low. It brings normality in the nation's data environment, and it also improves the business environment. The background of the Data Protection Act stems from the Malabo Convention of 2014, the African Union Convention on Cybersecurity, where member states established legal frameworks for cybersecurity and data protection. Why do we have the Data Protection Act in Zambia? So this is not a law that is only in Zambia, but it's a global law. It ensures that the risks of the 21st century in terms of technology advancement are curbed. It aids to reduce data breaches. It aids to eliminate identity theft. It minimizes financial losses, manages reputational damage, ensures that there's legal liability, ensures that there's no loss of customer trust, and it also minimizes business disruptions and ensures that there's competitive disadvantage. The African perspective of the Act. This is not an act that is only in Zambia, like I earlier said, but it stems from the Malabo Convention, which also ensures that there's the Cybersecurity and Data Protection Act. So in Zambia, we enacted the Data Protection Act in 2021, and all these resolutions that stemmed from the Malabo Convention. So there are about more than 20 countries in Africa that have enacted the Data Protection Act, mostly in West Africa, also in Southern Africa. So this just shows you that it's not a new act in Africa, but it's a regional thing that is going on in the world. Our act provides for data protection principles. There's the principle of lawfulness, fairness, and transparency. In terms of lawfulness, it ensures that the process is based on a valid basis. In terms of fairness, we have to ensure the act ensures that data is not used in a detrimental or unexpected or misleading manner. In terms of transparency, the processor must be clear, honest, and use data for its purpose, for the purpose it's collected for. Purpose limitation. We collect and process data for specific reasons and legitimate purposes. Our act ensures that data is not used for unconsented secondary purposes. The principle of data minimization is also in our act. Data must be collected and processed only for its specific purpose, and you avoid excessive data collection. Accuracy. We have to ensure that when data is collected, it has to be collected in a manner that it's updated and accurate, and that data should be complete and there should be quality in terms of collection of data. Our act also has the principle of storage limitation. Data should be stored for a limited purpose and for a specific period for its intended purpose. Any data that is which is no longer required should be deleted. Accountability. The issue of audit, appointment of a data protection officer, and responsibility for the data processors and controllers is also one of the principles that is stemmed in our act. Data integrity and confidentiality. Data must be protected, must be used in a confidential manner, should not be, and also have to ensure that it's not modified or disclosed in an authorized manner. Our Act also talks about the data subjects' rights, being respect for individual rights, the issue of consent, access to data, erasure of data, restriction of processing, data portability, objection, and rectification. Key provisions that should be known by users of the Act. We have Section 71, which talks about personal data. The data controller or processor must store personal data on a server located within the Republic. Apart from the responsibilities that are stemming from the Act, our Act is also a fair Act, because apart from the detrimental part where a data controller or processor is told not to use information in a certain way, it also allows for a leeway to store data outside the Republic. We have Section 72, which states, despite subsection 1, where the data controller or processor is not allowed to store data outside the Republic, the minister may prescribe categories of data that may be stored outside the Republic upon the recommendation of the commissioner. Section 71 provides that a person shall not engage in data transfer outside the Republic, but such transfer is restricted unless the minister has prescribed the transfer outside the Republic, the receiving country has adequate data principles, the policyholder has provided explicit consent, and that Data Protection Commissioner has approved the transfer. This is all to ensure compliance, and insurers should conduct due diligence on third-party data recipients. Another mandatory provision is Section 19, which states that a person shall not control or process personal data without registering as a data controller or data processor. A data controller and processor should appoint a data protection officer. Under Section 81, the Data Protection Commission also provides for an auditing license, and an auditor has to apply for this license. It's a requirement under the law. The data controller shall notify the Data Protection Commissioner within 24 hours of any security breach affecting personal data that has been processed. The law also provides for offenses. We have Section 18, abrogating the principles of data processing by corporate bodies. The principles that I went through in our Act. So if you don't comply with the principles, it's actually an offense. Abrogating the principles of data processing by data controller, we have a penalty of 400,000, 5 years imprisonment, or both. Under Section 19, it's also an offense to fail to register as a data controller or processor. Under Section 55, failure to comply as data controller or processor by corporate body, there are fines that are there. Section 55, failure to comply as a data controller or processor by a natural person, there's also imprisonment and a fine that has been prescribed in the Act. I'll hand over to the Commissioner to talk about the key provisions of the Act in relation to startups.
What you note is that the Act is not very friendly in terms of not being compliant. If you're not compliant, it will follow you, and there are consequences towards that. So the number of principles, the number of provisions that are relevant to you as startups. Remember, even if you're a startup, you are dealing with data. That data is not yours, and the owners of that data have got rights to that data. Meaning that if you do not follow some of the principles, you may find yourself being sued. This is why it becomes very important for you to ensure that you adhere to these principles that are now laid down. Remember, 10 years ago, 15 years ago, you could literally do anything without fear. Today, a data subject, the person who you are playing around with the data, whose data belongs to that person, today has the right to sue you. And this is why it becomes critical that you ensure that you develop or do whatever you want to do with data, but following the principles that have been laid down. You'll be required to register as a data controller. Registration is for a purpose. We want to know who's handling whose data. Remember, some of the systems that you'll be writing systems for not only small entities, writing systems for big entities. And therefore, you'll be coming across serious data. This is why, despite you being a startup, we want you to register so that we know which startup is doing what and what type of data they are dealing with. Remember, there is also another set of data that is more critical for us, the sensitive data. Tomorrow you'll be writing systems for the medical institutions. You'll be writing systems for the vulnerable people in society. And those now, that data to us is even more critical in the sense that it is what we term as sensitive personal data. And this is the very reason why you need to ensure that whatever you are doing it in conformity with the law. Remember, as I mentioned, data has become gold today. It's a new oil. Why is it being said so? It is because even the oil companies, some gold mines, they can't match up to institutions that are dealing in data. And this is why today data has become a commodity that needs to be secured. And that is what you'll be playing around with as a startup. You'll be dealing with data. And hence, it's very, very important that even in your systems, as you develop systems, you should ensure that access to your systems is extremely put in place so that the security measures that you need to live up with, they are met. Otherwise, you may have challenges moving forward. Again, some that you may need to take into account of is there are some restrictions in terms of data. Today, data will not just be moved around from country to country. There are a number of rules that you may need to follow. This is why also it becomes important for you to understand what you need to do with this data going forward. In the past, there was no reason for you to understand what is it that you need to do with the data. But going forward today, now, there are consequences, and hence it's important for you to understand what needs to be done with the data that you'll be collecting. Remember, there are penalties for non-compliance, and these penalties are not very, very friendly. Why is compliance good for these startups? You'll be dealing with the systems, or you'll be building systems that will be used by a lot other institutions. And an institution that understands the environment now, they would want to deal with a developer who's conforming to some of these rules that are applying today. Therefore, ultimately, there is that trust that to be built, and that it's incumbent upon yourself to ensure that you conform, ensure that you play according to the rules that are obtaining today. Remember, again, a startup who does not follow the rules, the startup that follows the rules, there'll be that differentiation. And that now comes into building your own reputation. Start early, ensure that you build a reputation that you're a startup who's conforming to the rules of the environment, the rules of today's environment. Remember, again, you are dealing with data. It now becomes very important that in whatever you do, ensure that the risk of that data finding itself in wrong hands is well managed. It all starts with you conforming to the principles that you come to learn that are in this act, because that becomes a critical ingredient to whatever you'll be doing. Don't forget, you are dealing in a you are in a global environment. Your system that you are writing today is not a system just for Minister of Technology. It's not just a system for an entity that in Zambia. It could be a system that will find itself outside. And the outside world that you are trying to go into, it also has these same rules. And some of the rules will be, is this system compliant? If it's not compliant, it will not be able to compete favorably on the world market. This is why it's important that even as you design your systems, the default should be that data should be protected. Ultimately, if you follow all these rules, even just the customer confidence that you will create, it will be different from those ones who will not have followed the rules of the game. How does this act affect you? You are required to register. However, because you are startups, we will not expect you to pay the registration fee. We will forbear you from that because we take recognition of the fact that you are a startup and we don't want to increase your cost of doing business. However, like mentioned, we still want you to register so that we know what you are dealing, which data you are dealing in, because you could be dealing with the sensitive data, you could be dealing with health data, whatever type of data. For as long as it is data, for us, we want to know who's dealing with what data. So, in as much as we will forbear you from paying the registration fee, we will still require you to ensure that you are registered. We're encouraging you that understand the Data Protection Act, because these consequences of not understanding it or not being compliant, they do not excuse you. You are not immune to that. Even if you've not paid the registration fee, we expect that in the way you conduct yourself, in the way you deal with data, in the way you develop your systems, you still need to ensure that you abide by the Act, because the Act cuts across everybody. Remember, there are customer expectations. Customers will demand a number of things. They will want to be sure that their data is secure. They want to know how you're using their data. And all those facets that we're talking about, eventually they'll affect you as a startup if you're not conforming to the requirements that are being laid down now. It is very important that you keep updating yourself, because this is a compliance requirement, and from the Commission's point of view, it doesn't matter whether you're a startup, it doesn't matter whether you're government, whether you're an NGO. For us, we continue to monitor to ensure that everybody is compliant. Because remember, we want to ensure that this act, we treat everybody fairly and transparently. So it doesn't matter whether you are young or you're a startup or you're a multinational or you are whatever it is. We expect that you comply, and therefore expect that we'll still monitor you to ensure that you are compliant. There are a number of resources that are available for you as startups. Firstly, the Commission is there to assist you to ensure that whatever you need to do to ensure that you are compliant, the Commission is open and will work along with you. There are a number of government and regulatory bodies that will assist you. The first one, of course, is the Data Protection Commission in relation to this act, because we're the last people who would want to see you being penalized because you are not compliant. And yet compliance is very, very easy to follow. Ensure that you get trained. You have institutions such as Bongo Hive who from time to time organize sessions such as this, so that you keep on upgrading your knowledge, ensure that you learn more and more in relation to being compliant. Again, they are accredited experts who will help you along the way to ensure that you are compliant. They'll also be carrying out some training sessions, which it will be very, very important for you once in a while that you attend those training sessions so that you build your knowledge to ensure that you remain compliant. Remember, it's very, very cheap to be compliant, but it's extremely expensive if you decide not to comply and you find yourselves being in breach. For you as a startup, you can imagine that your business gets curtailed at the early stages, all because your system is not compliant. Why should it be like that? Compliance is very, very cheap. Ensure that you comply with the laws. March, we started registering controllers. Controllers, in a simple term, anybody who deals with data for as long as you collect that data and decide what to do with it. In this case, you as a startup, because you collect that data and you play around with it, will require you to register. And registration commenced on 3rd March. You can go to our website and register. We will not charge you the registration fee that we are charging, but that we're charging other entities. Download the guidelines and just read through so that you understand what is it that you are going into. The guidelines have been drawn up in a more friendly manner, the English which is not so legal, so anybody else can read them and be able to understand them. You are expected to ensure that you register before 30th April. After 30th April, if you don't register, we may take it that you are among those who think that this law is not necessary, and therefore we may want to call upon you and start to have discussion with you. But that's the last thing that we expect from you. All we expect is you are a startup, you are in a business environment that has got rules, follow those rules, and ensure that you do everything that will make you a successful startup. Thank you very much.
Thank you, Commissioner, for the insightful presentation. First of all, let me just let you know that we have about 220 people on this webinar, so we won't be able to address all the questions because there are a ton of questions right now that have been asked. But I think one of the important aspects as we begin to address the questions is access to the Commissioner. How can people access you? Do they need to come to the office? Are there email addresses, numbers that will enable people to have easy access to the office?
The Commissioner's office is a public office, and therefore you can always walk to the Commission and push through your inquiries. On the screen right now is my phone number. You are free to call it, but also you can find the other contact details on our website. But we'll gladly share that with Lukonga, and please you can distribute that contact information so that all those that have got queries they can get in touch with us.
Great, and there was a request also for us to share the presentation, so I'm hoping that you can share it with us as well.
There's no problem. It's a public document. We'll share it with you, and you can share it with everybody else.
Okay. Just now to get into the questions, and I'll try to go through the questions as fast as possible. There, in some cases, some discrepancy between the information that's maybe on the website and how to register, whether there are links. Maybe you can just clarify a bit on that, because we have a few questions around simply the registration process. You have addressed application fees and such. Maybe you can just talk a bit about the registration process. Yeah.
Registration has commenced, and For as long as you deal in personal data, you are required to register. However, as mentioned, we are recognizant of the fact that there are groups of people like the startups who, despite us requiring them to register, will not push them to pay the registration fee. So let them not mind so much about the registration fee. Let them just proceed and do the registration.
Thank you. There was also a question around the data controller in the company. What is the qualification for them to be selected? Should they be within the company, outside the company? What is the criteria that startups should use in selecting the data controller?
A data controller, just for clarity purposes, a data controller is the entity that controls the data. Then the data processor is the entity that processes data on behalf of a data controller. Then for some institutions, depending on the amount of data that they deal in, they'll be required to employ a data protection officer or subcontract a data protection officer. It is this officer who required to have certain qualifications, and these qualifications will be published on the website. For the data controller, which is in this case, for instance, an entity, you have a number of employees within the institution who will be dealing with data. Now, these employees within the institution, they need to understand a number of aspects about the law, because that is where the data breaches may happen. And remember, this law is not immune to, does not exclude anybody else. Everybody who deals with personal data, if you're in breach, you can be held liable. Therefore, in as much as you may be working for an entity, if it is you who committed that breach, it will be you who will be held accountable. This is why we are insisting on the entities, which in this case are the data controllers, to ensure that they have their employees have some reasonable training so that they can understand the do's and don'ts. Because in the past, there was no regulation on how you manage this data, what you do with the data. Today, anything that you do which is not in compliance with the law, you may find yourself being penalized. This is why there's that aspect of now the employees in an institution being trained.
Thank you. There are also some questions here around the criteria for guidance on the exemptions for storage of data outside the country. You have stipulated in there that the minister can make those exemptions, but is there guidance? Because obviously a number of startups store data on cloud platforms, which are most cases outside the country. So what, at this point in time, do you have any criteria as to how you will make that decision? If you can provide some guidance on that. There are quite a number of questions on that.
We will give guidance on which data can be processed or transferred outside the country. A good example is, for instance, the insurance industry. The insurance industry, because of the nature of their business, at end of year, they need to ensure that that data is transferred outside the country for actual evaluations. Certain risks which could be very, very big, they need to reinsure them. So data will be transferred outside the country. So one of the criteria for transferring data outside is the nature of business. But now it is the data controller or the owner of that data who should come to the commission or write the commission and seek for that exemption. That because of the nature of business that I'm involved in, I want to be transferring data to outside Zambia. For those where we already know, for instance, like the insurance industry, we will give blanket authorization But if you're in the insurance industry, you are allowed to transfer data. If you're in these other sectors, it is you to come and justify to us why you, for instance, want to transfer data outside. I would pose a question. Why should the Lukonga's transactions, which he sends to Likando, sends to Peter in Matero, and somebody in Mongo, be transferred outside Zambia? So this is why we expect the entities that want to be transferring data to be able to make an application. Then we'll look at their applications and guide accordingly. In terms of processing, by default, you are supposed to process locally. However, there are circumstances that will make it not possible that all systems have the processing done locally. One, a number of them, for instance, the passport system. Passport system is a global system. It has to be accessed from anywhere by many countries. Therefore, you cannot insist that let that solution come and sit locally. However, there are certain solutions which just do not make much sense as to why processing should happen outside. And remember, it is also to the benefit of the country. You tell me what good would it be to the country if a point of sale system, the processing is happening outside Zambia? How does that help us? It doesn't help us. This is why we'll have a number of criteria that we'll use to allow for data to be processed outside or to be transferred outside the borders of Zambia. But it starts with the entities that are affected applying and justifying. There are a lot of reasons. If an entity comes and says the local data centers cannot host my data is too much, we will understand. But it's the reason that we're looking for from the entities that are affected.
Thank you. Another question here relates to what you had referred to earlier. We have startups that are building platforms for other businesses. And the question here is whether the actual startups that are building that infrastructure, the technology infrastructure, should register, or the companies or the clients themselves that own these systems are the ones that should register.
No, the startups themselves should register, because the companies that will own this data, they will have registered already. But remember that it is not the startup who will now eventually be dealing with this data as well. So we expect the startup to register as well.
Okay. Another question here in relation to hosting of data outside the country. Are there any hosting platforms outside the country that already have been approved by the Commission?
We are yet to approve that. Remember, we have a number of cloud service providers locally, and we believe that they should be able to handle all requests to do with the data storage and the like. However, there will be a time that we may now allow that data can be stored in certain international clouds, but that we haven't done yet.
Okay.
That, however, does not stop the startups from developing systems, because during the development process, you're not dealing with 500,000 records. You're just dealing with 10, 20. So it is fine. You can develop a systems on the international cloud, and the few records that you're dealing with, you can do that. But now, when the system has matured, and now it is storing 100,000 records, at that point, we want you now to come and declare that this is what's happening, so that we can follow up on where this data is being stored.
And that's a very interesting point, because we have a question here around the point at which a startup should actually register. So if I go to Parkrun, register a startup, should it be part of that registration process that once I leave PACRA, I also register with the commission? Or there is a period of time, and what criteria would that be till I am deemed as a startup that needs to register with the commission?
Firstly, it also starts with yourself. We don't expect that even before you start your development journey, you register with the commission. You yourself should know at what point you need to now to come to the commission and register, because you know what type of data you now started dealing with. Whether that data is data that can also harm you, because remember, the data that you be playing around with or that to be on your systems is not yours. It belongs to somebody. The moment you realize that, it's time to think about coming to register, because it is that somebody who may sue you because you did something wrong with their data. So at the very beginning, we don't expect you to leave PACRA and come and register. No. But at a certain point, you should be able to know that now I've started dealing with bulky data. I think it's time for me to register with the commission. We're also trying to safeguard you, because once you now come to the commission, we'll now also be able to make you understand the environment that you're operating in and how you need to conduct yourself going forward, because anybody can wake up and sue you because you're dealing with the data.
Thank you. There's a question here around the creation of a separate act for sensitive information. So the question here relates to the HIPAA in the USA, the Health Insurance Portability and Accountability Act, which focuses a lot on or focuses on sensitive information. The question here is whether Zambia could at least take that direction so that we don't classify all the data as being sensitive.
We could be moving in that direction, but maybe not now. Remember that we have the Personal Data under Data Protection Act. Right now, we have the critical data under the Cyber and Security Act. So we could move to that direction, but I think it will all be dependent on the challenges that we'll face with the two acts that we have. If at all we need to further separate classify the data separately and have a separate act for that.
Okay. We focus now on emerging technologies, AI, blockchain, and such. Are there specific provisions or an approach which startups could take for these technologies that in most cases do not have any local hosts that are able to manage these kinds of technologies?
We don't want to rush into everything. You know, we are in technology, and technology is changing every other time. So we'll start with the basics. For now, the blockchain, the AI data, we are not really concerned with it until a certain stage. That's when we'll get to that. But for now, be rest assured that if your systems are running in that environment, there is not much problem with the Data Protection Act.
Maybe let's circle back a bit on access. We have a number of comments here that have come up simply related to accessing information on the website. So a number of people are unable to either download information or forms or simply access specific information on the website. Do you have any answer to any alternatives possibly that could be there?
We had a bit of challenges, I think, the past week, but I think those challenges have been resolved, and the website, it should be up 100% now. But we are also monitoring it very, very vigorously, because for us, the everything that we are doing, a good portion of it is on the website. Therefore, we ensure that the website is 100% up and running. But in an event that we have certain information that people want to download, what to also do with liaise with the office, whatever we upload to the website, we'll also give you a copy as Bango Hive, so that your startup colleagues, maybe you can help to disseminate that information to them.
All right. Moving along to the health, there's a question here related to the health sector because they deal with sensitive information. There is a question here, if data is transferred from a company here to another company in another country for expert analysis, which company is supposed to apply for outside country data transfer?
It depends. It depends on the circumstance. Remember that the law allows that data can be transferred. For instance, if data is being transferred for medical reasons, we don't have a problem with that. All that is required is that the consent, blanket consent, that will be given for such type of data. Where we have an issue is where you are a medical institution in Zambia, and almost all the data that you are dealing with is being transferred. That now becomes a bit of a problem, because we need to understand why are you doing that. Because the other side of it is here's a patient who's going to a hospital, and that patient now maybe needs to go to India, meaning that that file needs to be transferred to India. We'll not have a problem with that. But here's a medical institution which has got 50,000 records of patients, and that data is not in the country. That becomes a little bit of a problem.
Okay. So I'm trying to process as many questions as I can. There are lots of questions. There's questions here related to data centers themselves. How does this affect the data center providers?
Remember, data has become the new gold. Therefore, from our end, we want to ensure the security of this data. From our end, we're encouraging institutions that are processing data and the servers are under their desks and the like, that they should start using our local data centers. Because remember, that data that is running on that machine is not yours. And if anything goes wrong with that data, there's a risk of the owners of that data suing you as an institution. Therefore, it just works very well for you as an institution that now that you have local data centers that can host your data, for you to just move that data and co-locate it with one of the service providers. Besides, it's even cheaper. You can imagine in today's environment, you need cooling, you need 24-hour power, you need the security. All those things put together, they become unnecessary cost for an entity. Therefore, it's about time entities started thinking critically that they don't need to be storing that data in their local data centers. Let them utilize the data centers that we have. We have a number of them in the country right now. All of them are on annual basis. They are certified. They are running at international level. Therefore, there is no fear that there is any risk that cannot be mitigated as far as their data is concerned. Put your data at one of our local data centers, and you are home and good.
Commissioner, you are touching on a very hot subject here in the questions, and I also have personally had challenges with this. From a startup perspective, it's really around the cost of hosting locally, and also the kind of service. I mean, we cannot expect a local hosting company to maybe compete directly with Amazon or Google Cloud. And so what we experience and what many startups experience is definitely a much better service if and when they host with these really established cloud providers. So there's definitely a disconnect or gap between the local service providers and the global companies. which maybe touches on a bit on the aspect of giving special what you call it, permission for startups to at least exemptions, yes, for startups to still be able to host internationally, and at the same time find a way of working with local cloud providers to either improve their services, reduce cost. So I see it as a journey. But I think for now, startups see and the experience with local providers is not at the same level as the very established global companies. So there's definitely a process, but I want your perspective to how startups can then approach this, because it's not simply a black and white issue. It's very much a gray area from where the startups stand. They need to save costs. They need to be able to do things faster. But of course, we understand there are also challenges locally. So maybe you can talk a bit about that disconnect. Yeah.
We are very much alive to this challenge. Remember, startups, you want to use these international clouds because they have almost all the tools that you require. All you need is internet connectivity, and you can start your development process. So we are very much aware about this joint, which may affect the startups. This is why we mentioned that startups will be given a lot of leeway in the way we manage them and the way we regulate them. Firstly, we'll not even require them to pay registration fees. In cases where they are involved in development, we want to ensure that their cost in this journey is not increased because of the Data Protection Act. Therefore, we'll give them a number of exemptions. We have a number of institutions that have made that application, that we have this system that is running in the cloud, and to bring it locally, this is the cost and the like. Depending on how they've put their case, we've understood. So in the same vein, startups are in that category where we want to ensure that we want to support them. Therefore, we'll listen to their stories. And it is up to them to just come through and make that application that for the system that I would like to develop from a second cloud, and we'll vote with them that exemption.
Great. A few questions here. There's a question here around how this maybe relates to GDPR, and in this case, things like putting up a data privacy policy on our websites and the cookies banners and all those things. Are those now going to be mandatory for websites?
Remember, the Act is also trying to safeguard you as a player in between, because you may get sued by those who understand their rights. Therefore, most of these things that you are seeing, that maybe you are seeing outside, and they were not applying in the country, now they'll be applicable. So in the next few months, those will become mandatory. Besides, we expected that even before enforcement commences, because the Act is already in place, those things should have already been worked on. We should already have started complying to some of these basic things. So whatever it requires to be complied with, just take note that you need to comply with that.
Okay. Does the data protection officer need to be in Zambia, or they can be in another jurisdiction?
You are in South Africa, and you're protecting data that is in Zambia. You know, even mathematics would say it can't. We may not allow that for now. But remember, the default is that the data is local. And therefore, if the data is local, then even the DPO, data protection officer, should be local. So for now, that's how it is.
Okay, thank you. The Act gives a period of 60 days to have deemed an application as accepted. There are some here who have applied or applied last year. So does that entail that their applications have been accepted?
We will issue certificates to them shortly. I don't think we've got much of a problem in terms of those that applied and haven't received their certificates yet. But we can deem it that we've accepted. What's important is that even themselves, they should now start complying with the laws.
Okay. Is there guidance regarding the minimum security requirements, technical or at organizational level, to process personal and sensitive data?
Or be getting to that. Remember, we're enforcing a number of security measures. This is why, for instance, we are saying if you are processing data and the server is seated in your office, already to us that is not acceptable, because then you're not even meeting the basic requirements that we're looking for ourselves. So a number of measures will be put in place, which people will need to follow, because that's exactly what we require from all the entities. Don't forget, you are not dealing with data that is yours. You are dealing with the data that does not belong to you. Therefore, it's part of our mandate to ensure that we put in all the necessary measures to ensure that this data is secure, and that will also go to what needs to be done in terms of security.
Okay, thank you. I'd asked a question earlier around local companies that are hosting data outside the country. We also have companies that are outsourcing their software development to other companies outside the country. And in some cases, that data actually stays on their system. So what is the guide on this?
We believe that, for instance, a local entity that has got an international partner, we could have partnered in developing a system. At that point, really, there's no much fear, because it's only the conduit that is being affected. The data itself is not affected. We'll only get concerned if that data starts to move from within the country to where the development is happening, if it's outside the country. But in terms of partnerships, there is not much problem with that.
Just in addition to that, so if the software development company itself is sitting outside the country and the data also is sitting outside the country, which the software development company is also working on, what should be the guide for that company that is outside this country but processing some data for a company that is based in Zambia?
There'll be guidelines towards that. Remember, if it's a software development company, if you are developing software, you don't need 5,000, 10,000 records to test your system. But if you're a software company and it is a stage where you need such kind of quantum of data for you to be able to be thorough with your system, then we come in as a commission. So, but we issue guidelines in relation to such kind of scenarios. Remember that there are a number of scenarios that we may not have come across, and we'll only be coming across them through interactions of this nature, where he's a developer, he puts up a scenario that, look, I'm a developer, but I've partnered with a colleague in India, and this is what we're doing. That could be a very, very new scenario altogether. We'll look at it at that point when that comes to us.
Thank you. There's a question here around training. and also accreditation of those trainers. Has the Commission have any plans around either the accreditation, or is there a list of training providers that organizations can already start working with?
Yes, the Commission for the past 1.5 years has been working with a number of entities, either individuals or companies, in building up guidelines and regulations for the Data Protection Act. So those automatically they've become our accredited partners for now. But in the next few months, we will open up and put up adverts for more partners to join those that we already have. But for now, the ones that were accredited are those ones that we have worked with, and we are confident that they can help us in this journey, especially at this stage when we're starting.
Thank you. There's a question also around parastatal state-owned entities. I guess, the question is also around whether they should register as data controllers or data processors or both. But as you answer that question, there are a number of questions here just around definitions, how people can understand whether they are one or the other. Maybe you can guide on that as well. Where can people kind of find that information? How best can they determine what they are, whether they're a controller, a processor, auditor, and such? Yeah.
The Act cuts across, whether government, whether NGO, whether private sector, whether multinational, you need to abide. At individual level, it doesn't matter whether you're a director or you're the owner of that institution or you're a processor in that institution, you still have to abide. So in terms of who's affected, everybody's affected. So the quasi-institutions or quasi-government institutions or whichever institutions, they still need to abide by the law. There will be those that may be exempted, and those that will be exempted or make known which institutions those are, but there'll be very, very few. Otherwise, everybody is expected to abide by this law. In terms of further understanding, you can also visit our website. A number of frequently asked questions, we'll put them on our website. You can be able to peruse through, and to give you some understanding of one of the things that are a bit gray. But in simple terms, a data controller is an entity or a person who controls or gives direction on how that data should be used, should be stored, or should be processed. Whilst a data processor is a third-party institution that is processing data based on instructions that are coming from a data controller. So those would be the basic definitions for the two. An auditor is an appointed entity that is licensed by the Data Protection Commission to audit on behalf of the Commission. Remember, we will not be all around the country, and therefore we shall license auditors. We shall license auditors who will help us to go and do audits in all these institutions that we will have registered as controllers.
Yeah, you have addressed a couple of questions there that we had around compliance and how the Commission will ensure organizations are compliant. That was there were a number of questions just around that. As you responded, I think, to one of the questions, and you talked about the fact that, or your observations, that self-hosting of data is not allowed. There are some startups that are able to host their data on their own servers in their own bedrooms, so to say, for lack of a better example. But maybe you can guide us on how we should approach those situations. Yeah.
It's a bit situational, but remember that you are dealing with data that does not belong to you. Therefore, the first thing that should come to you, even as a startup, is that this data that I'm dealing with is not mine. And if you're not managing it very well, you yourself as a startup, you risk being sued. And the act, like I said, is not friendly. If you are sued and we find that actually we're complacent, you should have followed certain rules on how you manage people's data or hold you accountable. However, in the early stages, when you are doing the development, we expect that even the amount of data that you are storing in on your laptop, on your server that is in the house or in the bedroom, I don't think it is that much. It's really data that is just there for testing purposes. Once that system has started running, there is no reason why you should have that system seated in your bedroom or in your small office, because there's a risk of that server even being stolen. And if it is stolen, for instance, you've got people's data that is on your laptop, it is you that we shall hold accountable. Therefore, the responsibility again comes back to you as a startup and as an initial developer to know what is it that is good for me and what is not right for me. There is no reason for you to find yourself in a problem on things that that can be resolved in terms of, for instance, having the data sitting at a data center while your development tools are seated on your laptop. There's no problem. So really, it's situational, but it starts with yourself recognizing that the data that you are dealing with does not belong to you. It belongs to somebody, and that somebody one day can wake up and sue you if it's mismanaged.
Thank you. There are questions here. One question specifically around, it's a good example. Within an institution, there are different people dealing with data. So they gave an example of how, for example, in manufacturing, right? Someone is entering data into an ERP system. There are other field staff entering crop data and all these others. So there's so many stakeholders, so to say, working with the data. What's your guidance on who should register then within these institutions? Yeah.
If you're an employee, we will not expect you to register. We expect the entity itself to register, and the responsibility for the entity is to ensure that all the employees within that institution are trained so that they understand their obligations, because the data that they are dealing with does not belong to them. So if you're an employee, for now, you are not you are exempt from registration.
And just building on that now, there's a question around who should now register the data controller, because a lot of companies process some level of data. And if you look at it face value, it looks as though every company in Zambia should register. And so what's your guidance on who you should register, because they all process some level of personal data in some ways? And one of them, for example, is a courier company or a ticketing company. The number of companies here that are asking the same question. Yeah.
We will give exemptions. We are very much alive to that fact. According to PACRA records, we have over 500,000 active entities. Some of those are smallholders, some of those are small holders. Therefore, we don't expect that all those should register. We will give a criteria on who should register. Among the things that you may just quickly need to bear in mind is that it all depends on the amount of data that you're handling. So if you're handling up to a certain threshold, we expect you to immediately register. But from our estimate, yes, it's correct that every entity deals with data, but we shall give exemptions to a number of institutions. We shall give a guideline on who should register and who should not register.
Thank you. There is a question, and I think you've tackled that question around the criteria and all. You have mentioned a couple of times about um, the criteria or guidelines being available at this at some point, and I think the startups would appreciate maybe some timelines to that, so that we know when to expect certain guidelines and all these documents that would be made available. Are you able to maybe give a general picture of what timelines you're working with around making sure that all the information or the guidelines are available as people register, that they know in 1 month or 2 months, we'll get this guideline, we'll get these exemptions and such. Maybe you can give a general or maybe specific response to that. Yeah.
We will try by all means to ensure that our website is as informative as possible, because basically it is the front end of the commission. So you'll find a lot of this information on the website. But for now, the registration guidelines, the guidelines dealing with registration, they are already on the website. And in the next few weeks, we'll also move on and add on some more guidelines. But as we do that, we'll be informing the public what guidelines are being pushed to the public. Remember that we also try and or continue to run adverts, because our guidelines are gazetted. Therefore, before they go to the public, we need to inform the public that the following guidelines are out, and we'll keep you informed. In terms of timelines, we hope that the next set of regulations should be available to the public before end of May. But in terms of guidelines, every other month we should have a set of guidelines that will be published and we put on the website as well.
Thank you. We've tackled quite a number of questions. There are now a few more questions that's left. There is also the aspect here of big tech companies, global tech companies that are holding our data. What is your approach to them to ensure that they also host that data locally, and that's in short, so they also comply? Yeah.
We are learning from other commissions who are a bit mature or have been already been operating for a number of years. It's an area that we definitely need to manage. We would also like to get a share of the proceeds that accrue to them because of them using data that belongs to a Zambian. So be rest assured that that's a matter that is being handled, and I think in the next few months we will have a clear guideline on how such type of data or how those big techs will be handled. But ultimately, we are at a situation where we want to partake into the revenue that accrues to them, because they are utilizing data for Zambians.
Thank you. There's a new, I think, law. I don't know if it's still a bill, but the issue around CCTV and that kind of data. We are all, entering in buildings, and we are using our biometric and facial recognition systems. What's your guidance on either the companies that provide that technology equipment to the organizations that have these kinds of systems that are hosting the biometric data, including CCTV footage and such? Yeah.
Biometric data, there is a regulation that will be signed shortly, that will regulate how biometric data is handled or is collected. That regulation should be signed in the next maybe 4 weeks or so, So the public should be comforted that we'll have a regulation that will manage that aspect of data. In terms of CCTV, there is a bill that a law that will be coming out shortly that will manage that aspect. But from the Data Protection Commission's view or point of view, that is data to us as well. Therefore, if you have a CCTV that captures public data, you are expected to register. We want to know what you're using that data for, how it is being stored, and where is it being stored. Because remember, you're capturing people's images, and those images are not yours. In as much as, yes, it could be for security reasons, but we are also concerned in how you use that data after you've collected that data. So there's that aspect where the data protection comes in, because you're dealing with someone's image. And there are rules how you go about with that information.
Thank you. We are almost done with the questions. Seeing repeat questions here, mostly around criteria, who can be a data processor, controller, and such. So my observation from the questions is that there is a lot of training that's required, awareness actually, people to understand just the definitions of some of these things. And hopefully this is a journey that we undertake together with the Commission, so that people are aware of what needs to be done. Like you said, also before any punitive measures come, that we are all together on this journey. So that for me is one big aspect of this particular webinar. And also from the questions, it is quite clear that to some extent there is a level of awareness that's required for people to be aware what needs to be done, with what category they fall under. There is also the other aspect as well of which is always contentious, the hosting, right? And you tackled that as well, because it's important for us as startups to reduce our costs, go to market as fast as possible. So for any exemptions that need to be put in place, I think those are quite clear from a cost perspective, that we don't have to pay to register. That is definitely a good move. I also want to communicate, I think based on the conversations today, that startups want to be able to interact with you, to feel that they're part and parcel of effecting the change, right? So, and I know in some cases, a number of us were not part of the process of enacting this bill and the Act of Parliament, but going forward, I think in operationalizing that, there will be a lot of feedback that the startups will be able to give you. I hope that, and based on this conversation that we've had today, that is information that you will get and be able to maybe adjust some of the processes and be agile as possible, because I believe that, startups, enterprises, small enterprises can have a huge impact on the economy. And these opportunities are for us to engage, so that we create a more conducive environment for us to do business. So those are my general remarks. As we come to the end of the session, I would also like to give you maybe an opportunity to give some closing remarks as well.
Before I give my closing remarks, the Deputy Commissioner will just give remarks, then I'll come in and close.
Thank you so much. We're happy to have this conversation with you, because it's part of our awareness process. And if we have as many people registering, even if they're not paying, as the Commissioner alluded to, for us, it's the numbers, and we want to know who our clients are. So we're kindly requesting that everyone just goes to the website, register, and upload the guidelines, read them, so that you know what you're supposed to do as either a data controller or processor. Thank you.
In In closing, remember this law is for the benefit of every Zambian. It benefits the data subject. Now the data subject has got some rights which they never had before. The startups, there are benefits that will accrue to you because now we are saying that certain things that were maybe being done outside the country, some of them will need to be localized and be done locally. There are examples such as, for instance, a call center. Call centers, some of the call centers that we have in this country, they are being managed from outside. Yeah. That already is an opportunity for the startups to start thinking about maybe there's a call center solution that I can come up with, which can be adopted by one of the entities within the country. So there are all these benefits that will accrue literally to every person for instance, in the IT sector. For the data centers, it's important. We need to ensure that those people that are managing data or managing data that does not belong to them, security is paramount. Remember that if this data finds itself on the streets by error, that itself has got its own implications because we may not even know the quantum of data that we are keeping and what type of records that we are keeping. Therefore, security becomes key to us, and that also on its own has got benefits to the entities themselves because ultimately some of this risk which they were carrying, they will no longer need to carry it forward because there are other entities that are best placed to ensure that that data is kept securely. For the Commission, we are open to all sorts of to all suggestions. Please, whatever queries you have, you've got our email addresses. The offices are open. You can anytime you can walk in and come and give us your concerns. We'll take into account whatever your concerns are. And just as it has been put by the Deputy Commissioner, we are grateful for this opportunity. We've recorded a number of concerns that you have. A number of them are common. We shall endeavor to use the website as much as possible. Most of the information, you'll find it on the website. So some of the questions that you've asked, which could be missing in the most frequently asked questions, we'll add them to our database and we'll move on together with you. We thank you very much for this session.
Thank you so much for making time to participate and also for your wonderful interaction. We will definitely reach out to everyone and share the presentation. I am very sure as well that we'll have follow-on sessions, maybe sector specific as well, just so that we can, I think, address some of the critical questions that will pop up based on specific areas of interest. So thank you so much, and we'll see each other on other webinars or in person. Have a nice evening.
Thank you all. What we can do for the article is just we can limit it to the number of them.
So maybe starting here we talk to no, it was specific for that.
And that's whatever questions that we might have.
Okay. Okay, I thought the internet had dropped. Okay, thank you so much. I would just like to say thank you everyone who was able to join this webinar. Thank you so much, Mr. Likando, and also the Deputy Data Commissioner as well. I think there were a lot of questions and I think people still have some questions for you as well. So he shared his email address and also his number as well, and you can also visit them at their offices. So please, please, please do take some time and visit them if you are unsure about anything that they might have mentioned. So here at Bongo Hive, we have these webinars. We have frequent webinars that address a number of topics that are important for startups and businesses as well. So you can just keep a lookout on our platforms so that you don't miss out any webinar or event around anything that you're interested in learning more about. Otherwise, thank you so much. This has been such an insightful session. And also thank you so much for the participants for joining in and engaging.
Thank you.